Hello and welcome back to another episode of All Out Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. In the last episode, we began a discussion on access to justice and the role of legal aid providers. So let's jump right back in with our guests, Bailey Bortolin, Director of Advocacy for the Legal Aid of Southern Nevada, and Alex Cherup, Executive Director of Nevada Legal Services. It's amazing to hear about what you were speaking to, Bailey, the cooperation and just like kind of the culture towards supporting people without representation. So can either of you or both of you share perhaps a story or a moment that kind of highlights the impact of legal aid, and especially as it pertains to self-represented litigants?
Yeah. So I teach the eviction clinic at the Boyd School of Law. And one of the things that I've built into the structure of that experience is requiring my student attorneys who are going to be handling eviction matters with their license under my license. They staff the Civil Law Self-Help Center inside the Regional Justice Court. It's the best way to learn the language. It's the best way to see what people's questions really are, how they navigate the process, how to interface with people who are really in a crisis. They've received a 7-day pay rent or quit, and they don't know what that means or what the next steps are. And as they go throughout the semester and become more competent and confident in their ability to help someone in that area of law, they can also identify cases that we can then take for the clinic of real people who are coming in and asking questions where we can tell who really needs a lawyer and who will be able to navigate the system with just a little bit of time and explanation provided to them. And so this last semester, the students met a woman who had tried to navigate the system herself and had filed to have an eviction sealed that hadn't occurred. And her name was being confused with someone else's, and she had tried to explain to the court that this eviction never happened. It's on her record. Can she get it sealed? And it was denied. And so she came back to the self-help center in tears. She wasn't able to locate new housing because those eviction records really prevent you in the screening process from being able to secure good housing going forward. And just kind of beside herself that she didn't understand why this was happening. And so the students took the case, and we went back before the same judge and were able to just explain what had happened and where the confusion was, and to do some research inside of the court system. And she was able to get her case sealed, and it was just a matter of needing to understand the language of the process well enough to be able to really explain to the judge what had happened. And she didn't have that knowledge. And that's one of those where the law is really an impediment as well. The process is not friendly. It doesn't make sense. The language is confusing. An answer is the first filing and not a response to something. There's just so many places where someone can get confused if they're not really, really comfortable with that process. And even the judicial officer at the end of that case really apologized and said, I know you were here before. I apologize. I didn't understand what you were trying to explain to me. Of course, I'm going to seal this. This should have happened the first time, but we didn't communicate correctly with each other. And justice was able to be achieved in that case, but it took a few more months than it needed to for a myriad of reasons. And so it's really identifying where somebody needs a lawyer to make their case better and where we are able to help people just by teaching them the process themselves as well.
That's an amazing story. Yeah, it's I know these processes are very complex, and yeah, people trying to navigate that process on their own, it's not only a challenge, but things like that can happen where just not the right things are being communicated. That's a great demonstration. Alex, do you have any?
Yes, and do want to acknowledge the great work that Bailey and her students complete on a daily basis, weekly and monthly basis. Because if you think about it, if those students were not in that program, and Bailey was not facilitating the ability of those students to be able to appear in court, then those individuals would likely be in that courtroom alone or confused, as Bailey's story points out, without really a next step. And would that eviction have been sealed? Maybe. The likelihood of it being sealed without those attorneys there, very low, however. And this eviction being sealed is a representation of what is possible when we think about the importance of access to justice. As far as my story, it's similar. It's also based in the preservation of rights because, as listeners know, the law involves fundamental rights, and access to justice frequently involves a very, very important part of the process and the protection of those fundamental rights. Just a little bit about myself. I started off at Nevada Legal Services as a staff attorney in our northern office. I was primarily working on cases in the 4th Judicial District Court. That's Elko, Nevada. Still the court that I've appeared in front of, appeared in, and judges I've appeared in front of the most. So shout out to the 4th Judicial District Court. But I had come back to Nevada after I had worked for a period of time as a public defender in New Mexico. So I was representing criminal defendants, now transitioning into civil legal practice. The reason why I came back to Nevada was a statute that had passed, which was called the Supported Decision-Making Act, NRS 162C. And that allowed for alternatives to guardianship to include a supported decision-making agreement, which creates the process for an individual to develop an agreement where they identify the supporters that they would like to assist in their decision-making, and they, through that, are able to have an alternative to guardianship where all of their rights are preserved. I had been involved in some disability rights advocacy throughout the course of my career, long before I was an attorney. And when I saw Nevada successfully pass and the governor signed this law, I was really interested in the practice of guardianship law in Nevada. This is also a couple of years after the right to counsel statute for adult guardianship matters, where if an individual is appointed a guardian, or if there is a petition for guardianship, that individual is appointed an attorney. And that attorney is a rights attorney, an advocate attorney. So not a best interests attorney. The difference there is that a rights attorney or an advocate attorney will represent the individual in their needs, wants, and desires, which sometimes may be in their best interest or sometimes might not have anything to do with their best interest. But that's the power of a robust access to justice, right to counsel statute, is it allows for individuals to have the ability to have counsel that will represent them in their matter, regardless of if it's in the best interest. And so this was great work that had been done by the Legal Aid Center of Southern Nevada. Barbara Buckley and many others were instrumental in this important progress. So I start off my career at Nevada Legal Services representing protected persons. So I'm appointed to cases in the 4th Judicial District Court where there's a guardian involved. I'm representing the individual who has the guardian. In my first few months, the Supported Decision-Making Act passes, and I'm able to have another tool in the toolbox to talk about alternatives to guardianship. Through that process, our representation of a particular client expanded. And what ended up happening was it allowed for us to create an alternative that protected that individual's rights. This was an individual who was a senior, who was living in a long-term care facility, who had limited range as far as decision-making, and was basically in an environment where she was unable to make her own decisions. Yet, she had individuals that she wanted to assist her in the development of the supported decision-making agreement. Under guardianship, the guardian has a whole host of decision-making rights, and rights are often lost under guardianship. So we have this individual who's lived her entire life the way that she wants to live. And now an individual comes in and is appointed by the court to make your decisions. The impact that has on an individual is extreme. So what we did is we were able, through collaboration with opposing counsel, introduce the idea of, hey, there's a new opportunity involved in creating an alternative to guardianship. And I think we might be able to try this out. And if so, we might be able to terminate that guardianship petition and create a way where this individual can make decisions and regain their rights and live in a way like they have throughout in almost the duration of their life before the guardianship. So as a result, through that collaboration, we found 2 supporters. We were able to prepare my client for testimony, introduce the supported decision-making agreement, and have an incredible hearing, where at the end of that 30 minutes, my client was able to leave the courtroom and say, I have regained all my rights. And I think she said something along the lines of, I have all my rights, and it is wonderful. If there were no self-help forms, if there was not our office involved in the representation of the protected person, if the statute had not changed for right to counsel, we could imagine that the situation might be a lot different. And as a matter of fact, I think this was one of the first supported decision-making agreements that was used as an alternative to guardianship. So from my angle, the involvement of all of us in the legal profession, being able to provide individuals the supports that they need, is what allows, in many cases, fundamental rights to be preserved, decision-making rights to be preserved, and quality of life to be preserved as well. And without this structure of access to justice, it's quite possible that none of this would have been able to happen.
That's amazing. Thank you both for sharing that. Guardianship's a very interesting topic, and it's humbling to consider what could have happened without the involvement of your office and legal aid. Hi everyone, I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. But I did want to ask you both, what would you say are some misconceptions, either from the public or within the legal community, about legal aid or self-represented litigants?
I think Alex touched on something really important that the community is not always aware of, which is when you have a right to a lawyer and when you don't. And so a lot of the people going through a crisis are very confused when they find out that they do not have the right to a lawyer and that securing one can be very difficult. So Alex touched on a really important one. We passed a right to counsel in guardianship matters in 2015. We also are providing that to minors in Clark County in a minor guardianship process. And we passed a right to counsel for children in foster care in 2017. This last session, the Nevada legislature did codify what was already a best practice of parents in child welfare cases getting a right to counsel. But outside of those, people have very high stakes where things happen that they do not have access to a lawyer for, but for these programs that, as we started at the beginning, there is a huge access to justice gap in our ability to provide a lawyer to every person who needs one. I think particularly in family law, the stakes couldn't feel higher when somebody's going through a high stakes domestic violence child custody situation. And also when it comes to your housing security, whether it's an eviction or a foreclosure in an economic downturn, the stakes could not be higher for some of these folks who are navigating the systems themselves. So whoever is interfacing with them, be it a self-help center, court staff, a judicial officer, just taking a little bit of extra time to try to use plain language and explain what you can really changes how someone interfaces with the system and their trust in that system. during what is one of the most difficult times in their lives.
I couldn't agree more with Bailey. The misconceptions related to legal aid are and legal services is based in, I think, the right to counsel discussion and a misconception about what is available to individuals, in that the Sixth Amendment right does not extend to civil legal matters. And so there are so many individuals who feel that there is that our offices provide support to criminal defense matters, to other types of legal needs that don't fall into that category. And also, uh, to add to that, you've got individuals who I think in general are of the belief that our offices can or have the capacity to address the totality of the justice gap, that our offices can fill that 92%. And unfortunately, the need is so overwhelming that, based on just sheer numbers, there will be individuals that, because of the incredible need, will be proceeding as self-represented litigants. I think that's a key feature, and it really builds on what contributes to what Bailey is saying, and what I'm saying here is the idea that there is not the infrastructure available at this time for individuals in matters that involve the courts, that involve their lives directly. There's not the infrastructure for everybody to have an attorney. And as a result, that means that people coming into the courtroom, they might have Bailey Bortolin as counsel, or they might have just been given a self-help form the day before when they printed it out from our kiosk. And that is, I think, the greatest misconception from individuals who are accessing services, is that understanding, as they're going through the process, that there might not be an attorney that is there for every step of the way. I think in general, for our audience, the judiciary and folks involved with the courts understand that. But as far as the general public, there is a learning curve about what is available to individuals in civil legal needs simultaneously while they're going through that process.
And one more thing I want to say on that is the legal aid providers were independent nonprofits, right? And so we are able to adjust and pivot and meet the needs of the community to the best of our ability with what the needs are. And so we are constantly evaluating what are the greatest legal emergencies that our community is facing right now, and how can we rise to meet that challenge? How can we adjust? How can we expand? Right now, that means we are staffing up in our immigration department as much as we can, right? And so one of the ways that we can connect with the judiciary is to identify what are those needs, what are those problems that you're seeing in your community, in your courtroom, and your caseloads, that we can partner on. And so please do reach out to us. There are judges from all over the state who will say, hey, we really need we need an ask a lawyer on this topic. My small town really could benefit from that. And we will figure that out, and we will provide that to your community. And so please do reach out if you're seeing things that are a point of frustration, right? Because you want people to understand the process. It makes it smoother for everyone involved. And we can help facilitate that if we open those lines of dialogue. So we are always open to that feedback of what pain points you are seeing from self-represented litigants, and from the trends happening inside your courtroom as well.
Yes, Bailey is spot on. And this is the importance of the philosophy of practice that our organizations incorporate. And that's the philosophy of community lawyering. Community lawyering is based on a couple of principles, one of which is connecting with the community directly. So we are looking for solutions that extend beyond just the legal solution by being in collaboration with resource providers, leaders, stakeholders, community members, we are able to look broadly at holistic solutions that exist. This is best represented by the collaboration between the 5 legal aid partners. We work closely and continuously to ensure that our services are provided to the greatest value to those that we serve. We will make referrals. Legal Aid Center of Southern Nevada handles particular matters such as immigration. Someone comes into our office and says, hey, I've got an immigration need. We will do the soft handoff to make sure that that person is in the hands of the individual who can provide that assistance. That no wrong door, one-stop shop model is how we in Nevada, through our collaboration, are able to operate. The second principle of community lawyering is that the community is the best situated to define the legal needs. And that's exactly what Bailey is talking about. The courts, in particular, are leaders in the community. If there are measures or trends or needs, we will adapt and we will provide the most robust type of supports when we hear those needs. A good example of this is I'm, as a new executive director, participating in an initiative I'm calling the 17 and 25 initiative. Nevada Legal Services is statewide, and 17 and 25 is a community lawyering initiative where I, as the executive director, and members of my team or members of the board are going to every county in Nevada, that's the 17, we've got 17 counties, and having community lawyering sessions and meetings with stakeholders, community level members, resource providers, and leaders. Last week, I was in Esmeralda County, Pershing County, Humboldt County. Next week, I'm going to be in White Pine County and Elko County. We've got some Ask a Lawyers coming up, and we also have meetings. And some of you that are listening may have met with me, and we've been able to incorporate and integrate that material into the provision of our services. I take that back to the Access to Justice Commission. I connect with Bailey at Legal Aid Center of Southern Nevada. I connect with David at Northern Nevada Legal Aid and the other legal aid providers. And we say, hey, here's where the needs are. For instance, in one of my visits to a rural county, I was having this 17 and 25 discussion, and it became quite apparent that the main legal need of that county was probate. That was something that we learned by that visit. The community says, hey, we might not have as many evictions here, because when it comes to probate, that's where the need is. So that allows us to adjust and to think, all right, now we need to work on that particular area of law. So the community lawyering and collaboration is the name of the game. And we are a committed group of organizations that are focused on making sure that we are relevant to the communities, and that also we are devoted to the development of trust at every step of the way, so communities and those that we represent can trust the work that we do.
Wow, I feel like we kind of just barely touched the surface on everything our legal aid providers do, and I know we could continue this conversation all day, but lastly, I want to make sure, is there anything else you wanted to share with the audience? And if anyone out there listening does need information or wants to reach out, what should their next step be?
I'll jump in, and as far as the next steps, I'll say the question is kind of a call for next steps. I think that the most important part of our conversation today is that this is the start of a conversation that is going to be ongoing in the meetings of the Access to Justice Commission and 17 and 25 initiative visits, and in our collaboration between legal aid providers. And I strongly encourage folks who are listening, if there's any question about organizations' responsibilities as far as what types of cases we cover, or is this something we can cover, or does this have, if there are restrictions that prohibit a particular office from taking a case, reach out to us. We, as legal aid providers, benefit from being able to hear that feedback, and we love to workshop ideas as far as what we might be able to do in collaboration. I will say that I didn't get a chance to talk too much about this, but our office in particular at Nevada Legal Services has particular restrictions because of the federal grants that are responsible for our funding. So there are certain types of cases that we can't take. For instance, we can't participate in class action lawsuits. And so if something of that nature comes to us, we might have to say we cannot take that particular measure, but then we will hand that off to Legal Aid Center or another legal aid organization. So that conversation and that discussion and that open dialogue is really important. I know that sometimes individuals confuse our organizations and think one is the other or vice versa. The names sound familiar, and so ultimately that open line of dialogue is important. Folks can reach out to me directly, listeners on this line, on our website, nevadalegalservices.org. You can find both a way to contact me or to contact other members of our leadership team. When it comes to those who are in need of services, there is an online application. Folks can fill that out, and our eligibility structures will be part of that process. So I think ultimately, communication, open dialogue, those are so important as we move forward. And just thank you, Seth, for being able to join you today. It's always outstanding to participate in something of this nature that talks about access to justice, talks about the importance of legal aid and legal services. And it's always a thrill to be able to present with Bailey Bortolin as well. So, and Brad Lewis, of course. But at the end of the day, I think as we move forward, feel free to contact us whenever you have a question.
Thanks, Alex. I would say thank you to the judiciary for those who are already partnering with us, already supporting our programs, volunteering their time on the Access to Justice Commission, volunteering on one of the many committees where we try to solve some of the identified problems that we've talked about here today. Because it really does make a difference. There are huge champions in the judiciary who think of these innovative programs and solutions and advancements that we can put forward, and we wouldn't be able to do it without them. It was one of the things that really struck me about the Nevada legal community when I first passed the bar, was being immediately thrown into some of these projects with Justice Hardesty and being able to make statewide changes and pass these right to counsels, and just how receptive the legal community is to solving a problem once it's been raised and identified. So we couldn't do it without the judiciary. In terms of reaching us, there's no wrong door. So if you are someone in need of services, reach out, walk into our office, call any of our offices, walk into a self-help center. If you want to refer someone, I'm always happy to be a clearinghouse and get you to the right place and the right person who can provide you with some information. We try to make sure nobody leaves at least knowing more about the problem that they've raised when they reached out to us. So we do have an incredible partnership and legal community here that you really see in how much the Access to Justice Commission is able to accomplish. We fix problems every year. It's nice to be on a committee that really does that and moves change forward. So thank you to Alex. Thank you for having us. And I hope to hear from some of you.
Thank you both so much, Alex and Bailey, for taking the time to speak with me and our audience about this important subject. And above all, thank you for everything you do for the people in our state. Just the work you guys do is so important, and it's so exciting and amazing to hear about these type of things taking place in our state and the support that is available to people. So thank you both very much.
Thank you so much, Seth. And thank you to the Access to Justice Commission and all those listening today.
A heartfelt appreciation to our guests and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. You can email us at jepodcast@nvcourts.nv.gov or submit your ideas to the topic suggestion form linked in the episode description. We value and look forward to hearing from our listeners. Stay tuned for more episodes of All Out Nevada. This is Seth Easley signing off. Take care, Nevada.